Welcome to the McNees Corporate and Tax Podcast Series. This podcast will address the Employee Partner Misstep by Shaun Eisenhauer, attorney at law. Mr. Eisenhauer practices in the corporate and tax group at McNees.
Thanks for joining me today on this podcast. Because of the flexibility in tax pass-through features, most businesses today are organized as LLCs taxed as partnerships. That's a good thing. An LLC should be your go-to entity for business formation. One important limitation we've seen many folks completely miss is this. Simply put, the IRS does not allow a partner to be an employee. This IRS position was recently reaffirmed in a regulation that went into effect on August 1st. So let's do a quick review. In a corporation, income is calculated and taxed at the corporate level. The corporation can then determine to pay dividends to its shareholders, and if it does, the shareholders pay tax on those dividends. Because a corporation is separate and distinct from its shareholders, a shareholder can also be an employee who receives W-2 wages, and conversely, an employee can receive an equity incentive in the corporation without jeopardizing his or her employee status. In an LLC taxed as a partnership, income is computed at the partnership level but passed through and taxed at the partner level. This is generally a good thing. You don't have the double tax of income at the entity level and the ownership level like in a corporation. However, this means that a partner in a partnership or an owner of an LLC taxed as a partnership is taxed on his pro rata share of the partnership income, whether or not the partner actually ever receives cash from the partnership. This is called phantom income. Now here's the problem. If a partnership interest is given to an employee, that employee becomes a partner and ceases to be an employee. We've seen several instances where a well-meaning LLC owner wants to give an employee part of the upside of the LLC by giving some equity in the partnership. That seems like a fine, even generous idea, but it's a trap for the unwary and can create a host of tax burdens for the employee and the LLC. The employee is now subject to the possibility of that phantom income we just talked about, imputed tax without sufficient cash to pay the tax. He might even have to recognize income from the grant of the partnership interest itself. The employee will get a partnership K-1 at the end of the year and may not understand what that means. Well, it means he'll have to include on his individual tax return his pro rata share of the partnership income, and this may give rise to an estimated tax payment obligation. All of the payments from the LLC partnership are now considered to be distributions from the partnership to a partner, not W-2 wages. This means the employee may now be disqualified from certain employee benefits or may even owe additional taxes on those existing benefits. In addition, while in a corporate setting, an employee and the corporation each pay 1/2 of their FICA taxes, in a partnership, a partner pays 100% of those taxes through quarterly estimated payments. In short, this well-intentioned action can create unintended, complicated, and expensive results. There are a variety of things we can do to avoid those expensive results. We can use tiered or related entities, S corporations, equity appreciation units, phantom equity. These are a few examples, but the essential first step is recognizing you have to do something to avoid these unpleasant results. And as we've noted, many folks don't. So, before you decide to give your employee a piece of the equity of your LLC, give me a call.